Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. LaShawn Henderson, decided March 19, 2026. Troutman. Generally, evidence of a defendant's prior possession of drugs is inadmissible at trial to show their intent to sell drugs or knowing possession of drugs on another occasion, e.g., People v. Valentin, People v. Blair, People v. Alvino, People v. Crandall. This follows from our long-standing Molino rule, which provides that evidence of a defendant's uncharged crimes or prior misconduct is not admissible if it cannot logically be connected to some specific material issue in the case and tends only to demonstrate the defendant's propensity to commit the crime charged. People v. Cass, see People v. Molino. When evidence of prior uncharged crimes or misconduct is logically connected to some specific material issue in the case, such as intent, motive, knowledge, common scheme or plan, or identity of the defendant, the evidence falls under an exception to the Molino rule, and a court may admit the evidence if its probative value outweighs its potential for prejudice to the defendant. Here, because the people's evidence of a prior incident involving defendant's possession of drugs was not logically connected to any specific material issue in this drug possession case, apart from defendant's propensity for possessing drugs, the trial court erred in admitting that evidence. Inasmuch as this error was not harmless, we reverse and remit for defendant to receive a new trial. 1. Early one morning in October 2019, a SWAT team executed a search warrant at a home in Rochester using controlled explosives to force open the door. Inside, defendant and his girlfriend were in bed in the south bedroom. Defendant's father was in the west bedroom with defendant's 11-year-old sister, and his grandmother was in the living room. While searching the premises, the police found cocaine, scales, and packaging materials like plates, razors, and baggies. They arrested and charged every adult in the home. A grand jury subsequently indicted defendant and his father on 3 counts of criminal possession of a controlled substance in the third degree, based on intent to sell, Penal Law Section 220.16, 1 count of criminal possession of a controlled substance in the third degree, based on weight, Penal Law Section 212.16, and 4 counts of criminally using drug paraphernalia in the second degree, Penal Law Section 220.50, 2-3. Before trial, the people sought to introduce Molino evidence of defendant's conviction of criminal possession of a controlled substance in the third degree based on weight after narcotics were recovered by police from defendant's vehicle in 2017. Instead of explaining a particular basis for which the people sought to use the Molino evidence, the people listed every possible reason, asserting that the evidence would show defendant's motive, opportunity, intent, identity, and absence of mistake or accident in committing the charged crimes during the jury trial. Defendant used the same modus operandi, and defendant had the requisite mens rea. Defendant opposed the application, specifically noting that there was no dispute as to the issue of intent. The court ruled the evidence admissible. The people called as witnesses 4 police officers who took part in the SWAT team's execution of the search warrant. The officers' testimony established the locations within the home where they found each person and each piece of contraband. The largest amount of cocaine was found in a sneaker in the west bedroom, which was the father's bedroom. Cocaine and packaging materials were found in the living room, where the grandmother was found. In the south bedroom, where defendant and his girlfriend were sleeping, the police found 3 vials of cocaine inside of another sneaker that was hanging on the wall, as well as paraphernalia in 2 shoeboxes on the floor. A witness testified about how cocaine can be cooked, broken down, and packaged, noting that 3 vials of packaged cocaine found in the south bedroom were of a dime bag size quantity compared to the large, unpackaged cookie in the west bedroom. Defense counsel's cross-examinations of those witnesses centered on the issue of constructive or knowing possession. He cross-examined each witness about the absence of defendant's fingerprints on the contraband, and he tried to establish the paucity of evidence connecting defendant to the apartment. The people called their Malini witness, an officer with the Rochester Police Department's tactical unit, who arrested defendant in March 2017. For the first time, the people explained that they sought to introduce Malini evidence only for the purposes of proving knowing possession and intent. The court's limiting instructions directed the jury to consider the Malini evidence for only those purposes. He officer testified that during a snowstorm in March 2017, he and his partner investigated a suspicious parked BMW occupied by defendant and 2 other men. He also testified about an Audi parked approximately 50 feet behind the BMW, which the officer knew was registered to defendant. The officer testified that he looked through the windows of the Audi and saw a white, rocky substance in little baggies in the driver's door, in plain view. After a search warrant was obtained, the car was found to contain cocaine, marijuana, defendant's ID cards, and mail addressed to defendant. The people then introduced a certificate of conviction showing that defendant had pleaded guilty to 1 count of attempted criminal possession of a controlled substance in the 3rd degree in satisfaction of the charges resulting from the 2017 incident and was sentenced to 1 year of incarceration. The court then repeated its limiting instructions to the jury. Defendant did not call any witnesses, but the parties stipulated that defendant's father was convicted of criminal possession of the cocaine found in the sneakers in both the west and south bedrooms with the intent to sell. That stipulation was read to the jury. During summation, the people referenced the Malini evidence regarding defendant's previous drug conviction and argued that defendant and his father were running a drug business together. The jury acquitted defendant of the 2 counts relating to the cocaine found in his father's bedroom, but convicted him of the counts relating to the cocaine and paraphernalia found in the living room and the south bedroom. The court sentenced defendant to prison for 8 years and post-release supervision for 3 years. At the appellate division, defense counsel argued that the trial court erred in admitting the Malini evidence. The court rejected the argument, stating that the testimony regarding defendant's prior conviction is relevant and admissible with respect to the issue of defendant's intent to sell drugs, inasmuch as it is probative of defendant's knowing possession of and intent to sell the cocaine located throughout the apartment. The court further held that the trial court did not abuse its discretion in concluding that the probative value of the evidence outweighed its prejudicial effect, and that the court's limiting instructions mitigated any prejudice to defendant. 2 justices dissented, concluding that the trial court erred in admitting the Malini evidence. They further opined that the error was not harmless. One of the dissenting justices granted leave to appeal. 2. To avoid infecting jury deliberations with forbidden propensity inferences, our state's Millennial Rule bars trial courts from admitting into evidence a defendant's prior uncharged crimes or bad acts, People v. Telfair, citing Millennial. The rule is of ancient origin and is rooted in that jealous regard for the liberty of the individual which has distinguished our jurisprudence from all others, at least from the birth of Magna Carta. It is the product of that same humane and enlightened public spirit which, speaking through our common law, has decreed that every person charged with the commission of a crime shall be protected by the presumption of innocence until they have been proven guilty beyond a reasonable doubt. Despite the venerable roots of this rule, courts sometimes struggle when considering its well-established exceptions, whereby evidence of uncharged crimes or prior misconduct may be admissible to prove some element of the crime under consideration. Telfair. For example, evidence of uncharged crimes or prior misconduct may be relevant to show 1. Intent, 2. Motive, 3. Knowledge, 4. Common scheme or plan, or 5. Identity of the defendant. People v. Leonard. But courts must not allow these exceptions to swallow the rule. To prevent that from happening, courts must engage in a careful analysis and avoid the temptation to apply these exceptions too broadly. When assessing the admissibility of Molyneux evidence, a trial court must first determine whether the people have identified some material issue other than the defendant's criminal propensity to which the evidence is directly relevant. People v. Denson. As we have explained, Molyneux evidence is only admissible if it can logically be connected to some specific material issue in the case and is directly relevant to it. Cass. It is the prosecution's burden to show this direct relevance. See Denson. Whether the prosecution met its burden is a question of law, not a question of the court's discretion. See Cass. As a result, at this step, appellate review of a court's admission of Molyneux evidence is de novo. If the evidence is relevant to an issue other than propensity, the inquiry moves to the second step, where courts consider whether the probative value of the evidence outweighs its potential for prejudice. The standard of review for this second step is whether the trial court's decision to admit the Molyneux evidence was an abuse of discretion as a matter of law. Lastly, if the court concludes that Molyneux evidence was erroneously admitted, harmless error analysis determines whether a new trial is warranted. Telfair. I. Constructive or knowing possession. The main issue at trial was whether defendant had constructive or knowing possession of the contraband distributed throughout 3 rooms in the apartment. We agree with the dissenting justices below that defendant's possession of cocaine in his car in 2017 was not relevant to that issue. The 2 incidents involved different locations, different circumstances, different theories of possession, and took place around 2 years apart. Our decision in Telfair is instructive. There, we considered a defendant's prior possession of weapons as Molyneux evidence in a trial for criminal possession of a weapon where the defendant claimed he did not know there were guns in his vehicle because someone else had packed it. Telfair. The people's Molyneux evidence consisted of 2 prior incidents when the defendant was found with guns and claimed he did not know they were in his possession, because in each incident his former girlfriend had placed them there. The trial court admitted the evidence for the jury's consideration regarding the issues of knowing possession and absence of mistake, 2 exceptions to the Molyneux rule. We held that the prior incidents did not fall under those Molyneux exceptions because they involved different guns, different sets of circumstances, different excuses, and occurred more than 10 years earlier. Like Telfair here, the evidence of the 2017 incident was similar only in broad respects to the 2019 incident. Defendant's plea of guilty to possessing cocaine found in a car registered to him in 2017 does not shed light on whether he had constructively possessed the cocaine and paraphernalia in an apartment where he was sleeping in 2019. The type of location was different, a car instead of an apartment. The circumstantial evidence of constructive possession was different. Cocaine found in a car registered to defendant, as opposed to cocaine found at an apartment occupied by 4 other individuals, one of whom, the father, had mail addressed to him there. And the theory of possession was different. Individual possession of drugs in a car, as opposed to joint possession of drugs in an apartment with others present. In the prior incident, the cocaine was also packaged in a different way, having been contained in 53 little baggies and bags. Here, by contrast, the cocaine in the south bedroom was in vials that were stored in one baggie. Further, the cocaine in the living room was unpackaged. It was leftover product on a plate where a larger amount of cocaine had been broken down into consumer-sized rocks. The cocaine in the bedroom of defendant's father was a large cookie, not broken down into smaller rocks or packaged for sale. We are not convinced by the people's contention that the Molyneux evidence here is similar enough to the presently charged offenses to be relevant. The people underscore that the cocaine in both incidents was mixed in with mail, but that assertion is not supported by the record. Nor is there assertion that the mail was in the same shoeboxes that contained the drugs. The cocaine in the south bedroom was in a pair of sneakers hanging on the wall. The only mail recovered was in a box on the floor of the south bedroom, which contained drug-dealing paraphernalia, not cocaine. The mere fact that baggies and mail were allegedly present in each instance is far too tenuous of a connection to be relevant. The only significant commonality between the 2017 and 2019 incidents is defendants being accused of possessing cocaine in both instances, which is exactly the type of propensity evidence that Molyneux forbids. If the dissent had their way, however, evidence of a defendant's uncharged crimes would be admissible any time a defendant denies engaging in a similar crime on another occasion, even if the uncharged crime cannot logically be connected to some specific material issue in the case and tends only to demonstrate the defendant's propensity to commit the crime charged. People v. Sin. Accord, People v. Weinstein. That would be counter to the foundational policy undergirding the Molyneux rule. It is elementary that evidence of a defendant's prior criminal or immoral conduct is inadmissible if it cannot logically be linked to some specific material issue in the case. Although such evidence has some minimal probative worth because of its tendency to demonstrate the defendant's ad character and general criminal propensity, it is excluded as a matter of law when it has no additional relevance to a specific issue because there is a very real danger that the trier of fact will overestimate its significance. People v. Huddy. The dissent's accusation that we are somehow following a concerning trend by this court of circumventing Molyneux's two-step analysis could not be further from the truth, given that we explicitly reaffirm that long-established analysis in this very opinion. The only trend that we are following is over a century of precedent, as is our obligation under the doctrine of stare decisis. Just as we have recognized that using evidence of prior gun possession to prove current knowing possession of different guns is not justified under Molyneux, Telfair, the same is true for using evidence of prior drug possession to prove current knowing possession of drugs. 1. Consequently, the Molyneux evidence here was inadmissible to prove constructive or knowing possession. B. Intent. As the people concede, evidence of prior acts offered to prove intent may fail at step 1 of the Molyneux analysis when intent is easily inferable. See Leonard. Here, the element of intent was not disputed by defendant, an unsurprising fact given our observation in Alvino that, in most cases involving criminal sale of drugs, intent is readily inferable from the sale itself, and evidence of prior uncharged crimes is neither necessary nor permissible to establish it. Similar to when a defendant is caught in a drug transaction, here, the intent to sell the cocaine is so apparent, under the facts and circumstances of this case, that the introduction of evidence of other and dissimilar offenses cannot be justified as an attempt to prove intent. The intent of whoever possessed the drugs to sell the drugs was not at issue and was readily inferable from the nature of the contraband that defendant was criminally charged with possessing. As defendant made clear in his opposition to the People's Molyneux application, there was no dispute about the issue of intent. Defendant's representations aside, the police found not only drugs in the apartment, but multiple scales for weighing drugs, unused baggies and vials for packaging drugs, and plates and razor blades, indicating that cocaine was being broken up into rocks for packaging and sale. The People's witnesses explained that the house had workstations for packaging the cocaine, and, as the People accurately stated in summation, the police didn't find any pipes and there was no paraphernalia indicating they were using drugs or smoking drugs. The only paraphernalia they found here was the stuff you need to sell drugs. As a result, the intent of whoever owned the cocaine to sell it was easily inferred from the People's evidence. Alvino. The facts in drug trafficking cases where we have held otherwise are a far cry from the facts of this case. For example, in Alvino, we deviated from the general rule prohibiting evidence of a defendant's prior drug sales because the defendant did not merely rest on his claim that he was not guilty of selling drugs. He testified to facts in the nature of confession and avoidance, admitting the lesser crime of possessing drugs but denying the greater crime of selling them. We explained that, by doing so, he reframed the dispute before the court and affirmatively attempted to convince the jury of his innocence, not just in this instance, but because his entire history was inconsistent with guilt. Under those particular facts, we held that the People were entitled to rebut that testimony by evidence of prior crimes, suggesting otherwise. Our current case, however, is more like People v. Blair, which involved a jury trial for various drug-related crimes. There, we held that the trial court erred in allowing Molyneux evidence in the form of a rebuttal witness who testified that approximately 8 months before execution of the search warrant, defendant had supplied her with drugs, which he had retrieved from a back room in his apartment. In reaching that conclusion, we said that whether defendant intended to sell the drugs, knew of their weight, or mistakenly or accidentally sold or possessed the drugs was never placed in issue by defendant. We further explained that the People's rebuttal testimony concerning an alleged drug transaction 8 months before the events for which he was convicted did nothing to refute defendant's claim that he had been framed, but merely tended to show his propensity to sell drugs. See People v. Crandall. Such evidence is not admissible when it has no bearing other than to show that defendant is of a criminal bent or character. Similarly, where, as here, defendant's theory of the case is that he was never in possession of the drugs found in his father's apartment in 2019 and that they were his father's drugs, the fact that defendant was caught with drugs in 2017 merely tended to show defendant's propensity to sell drugs, Blair. The 2017 incident was otherwise not linked to a specific material issue or fact relating to the crime charged in 2019. Defendant never asserted that the drugs found in the apartment were for personal use or were otherwise not being sold. His strategy at trial was to establish that all the contraband in the house belonged to his father, not him. Despite what the dissent contends, defendant's references to his father pleading guilty to possessing cocaine found in the south bedroom with the intent to sell did not make it somehow permissible for the jury to consider defendant's unrelated conviction of drug possession in 2017. Given that defendant never questioned what we phrased in Molyneux as the conclusive inference of criminal intent which proof of the act itself affords, here the intent to sell cocaine, the court erred in admitting the Molyneux evidence, Molyneux. As a result, we need not address the second step of the Molyneux analysis, since the People failed to establish at the first step that the evidence fell under an exception to the Molyneux rule. See People v. Cass. Having determined that it was error to admit the Molyneux evidence, we now consider whether that error was harmless. C. Harmless error analysis. The trial court's erroneous admission of Molyneux evidence was not harmless. A Molyneux error may be found harmless only if both the proof of the defendant's guilt without reference to the error is overwhelming and there is no significant probability that the jury would have acquitted the defendant had it not been for the error. People v. Arafat, quoting People v. Crimmins. That is not the case here. A defendant's mere presence in an apartment where the contraband is discovered, or mere knowledge that contraband is present, does not prove constructive possession. People v. Cota, see People v. Manini, People v. Headley. Here, once we discount the improper evidence of defendant's past possession of cocaine, there is scarcely any evidence of defendant's dominion and control over the contraband found in the apartment. Although the dissent repeatedly references residue allegedly found on paraphernalia concealed in shoeboxes located in the south bedroom, no one was charged with possessing cocaine found in those shoeboxes. Without the court's admission of improper propensity evidence, the jury would be left with little more than defendant and his girlfriend being awakened on an air mattress during a SWAT team raid after spending the night at the apartment of defendant's father in a bedroom where no contraband was visible. Furthermore, the inferences the dissent draws from this limited circumstantial evidence are highly debatable and hardly convincing. As a result, the proof of defendant's guilt without reference to the Molyneux error was not overwhelming, and so the error cannot be classified as harmless, People v. Smith. Accordingly, the order of the appellate division should be reversed and a new trial ordered. Order reversed and a new trial ordered. Opinion by Judge Troutman. Chief Judge Wilson and Judges Rivera and Holligan concur. Judge Canataro dissents and votes to affirm in an opinion, in which Judges Garcia and Singas concur. Decided March 19, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.